Good afternoon and welcome to today's webinar. It's diversity, equality and inclusion themed, and we're talking in particular about some recent gender critical belief cases. My name is Fiona Herrell. I'm a partner in the employment and immigration team here at Brodie's, and I'm joined today by Louise Usher, who is a colleague in the team. So in terms of what we're going to cover today, we're going to start by just thinking about what gender critical beliefs are and when gender critical beliefs are capable of protection under the Equality Act as a philosophical belief. We're going to move on to then have a think about manifestation or expression of gender critical beliefs as opposed to the holding of the belief itself. Then we're going to have a look at balancing competing rights and beliefs, and then we'll wrap up with some key learnings and takeaways. So as HR professionals, we are used to and experienced in dealing with clashes between employees in the workplace, and in particular clashes where employees have different beliefs. And so that might be over the years, we might have had cases where the individuals have different religious beliefs, or we might have had situations where there's a clash between somebody's religious belief and somebody else's sexual orientation. These cases that we're looking at today, many of them, or at least two of them, have been very well reported on, picked up in the press, and that is because the issue is quite a high profile one. And what we're really talking about here, when we're talking about gender critical beliefs, is in short, a belief that a person's sex, whether that is male or female, is biological and cannot change. From the case law, we can see gender critical beliefs being expressed in slightly different ways, and that is to be expected because these are individual people's beliefs. And it should be noted that there is no sort of legal definition of what a gender critical belief is. So Ms. Forstater believes that sex is immutable and not to be conflated with gender identity. Ms. Bailey believes that sex is real and observable, and that gender is a subjective identity. And then Dr. Mackereth, he expresses his belief in a different way. He talks about a lack of belief in transgenderism and gender fluidity, and that's based on him not believing that it's possible for a person to change their sex or gender, and that impersonating the opposite sex may be beneficial for an individual's welfare, and that society should accommodate and or encourage anyone's impersonation of the opposite sex. So you can see, even just from an overview of these three cases, that you could have gender critical beliefs expressed in a positive way, or you could have it expressed in a lack of belief way. So hopefully that sets the scene, and I'll pass over to Louise, and Louise is going to talk about when gender critical beliefs might be capable of protection under the Equality Act.
Thanks, Fiona. So religion or belief is a protected characteristic under Section 4 of the Equality Act. And under Section 10, a belief is defined as any religious or philosophical belief, and that includes a lack of belief. In the case of Granger plc and others against Nicholson, the Employment Appeal Tribunal came to the view that there needs to be some limitations on the protection that are afforded by Section 10, and in so doing formulated what's come to be known as the Granger criteria. Under Granger, in order for a belief to qualify for protection, there are 5 tests that need to be met. The first is that the belief must be genuinely held. The second is that it must be a belief, not an opinion or viewpoint based on the present state of information available. The third is that it must be a belief as to a weighty and substantial aspect of human life and behaviour. It must attain a certain level of cogency, seriousness, cohesion and importance. And finally, it must be worthy of respect in a democratic society, not be incompatible with human dignity, and not conflict with the fundamental rights of others. So Fiona is going to come on to discuss the background and the decision that's been reached by the Employment Tribunal in the Forstater case shortly. But before she does that, one of the preliminary issues that was raised in this case was whether Ms. Forstater's belief that sex is immutable and not to be conflated with gender identity qualified for protection under Section 4 of the Equality Act. So at first instance, the Employment Tribunal found that the first 4 Granger criteria were satisfied, but concluded that the claimant's beliefs were incompatible with human dignity and the fundamental rights of others, and thus fell foul of the 5th Granger criterion. The tribunal held that even paying due regard to the qualified right of freedom of expression, people cannot expect their beliefs to be protected if their core belief involves violating others' dignity and or creating an intimidating, hostile, degrading or offensive environment for them. The claim was therefore dismissed on the basis that there was no philosophical belief that was capable of protection. Ms. Forstater, though, as many of you will know, then appealed to the Employment Appeal Tribunal on that preliminary point. In reversing the decision, the Employment Appeal Tribunal highlighted that Section 10 of the Equality Act requires to be interpreted in line with the human rights enshrined in the European Convention of Human Rights, which in particular entitles individuals to freedom of thought, conscience and religion under Article 9, and also to freedom of expression under Article 10. There was some discussion in the case as to whether Article 17 of the ECHR, which prevents any person from relying on the terms of the ECHR as a means of destroying the rights or freedoms of others, would prevent Ms. Forstater's beliefs from qualifying for protection. But ultimately, the Employment Appeal Tribunal concluded that Ms. Forstater's beliefs, while they may be considered, and this is a quote, offensive and abhorrent to some, the only beliefs that would fail to qualify for protection under Article 17 would be those akin to totalitarianism, Nazism, or those that espoused violence or hatred in the gravest forms. It follows that beliefs which are offensive, shocking, or even disturbing to others can still be worthy of respect in a democratic society, and therefore can still qualify for protection under that fifth Granger criterion. So as a result of this decision, it followed that a belief that sex is immutable and not to be conflated with gender identity would be capable of amounting to a protected philosophical belief for the purposes of the Equality Act. That was then reaffirmed in the Employment Appeal Tribunal's decision in Mackereth against the DWP. Again, I'm going to come on to talk a bit more about the substance of that case shortly, but for now, suffice to say that Dr. Mackereth attempted to rely on a number of beliefs that he asserted would be protected under the Equality Act. Two of those were framed in, the first was framed in a positive way, which was essentially that in the truth of Genesis, a person cannot change their sex or gender at will, and attempting to do so would be pointless, self-destructive and sinful. And the second was framed as a lack of belief in what he referred to as transgenderism. The Employment Tribunal disagreed that those beliefs or lack of beliefs were capable of protection, and in particular concluded that Dr. Mackereth's beliefs were not capable of respect in a democratic society. I think it's important to say at this point that that decision was reached prior to the Employment Appeal Tribunal's decision in Forstater, where it was established that her gender critical views were worthy of respect in a democratic society. So on appeal, the EAT found that the tribunal had made a number of errors in its approach to whether Dr. Mackereth's beliefs were capable of protection, and specifically that the Employment Tribunal had imposed too high a threshold in relation to the requirement that a belief must be worthy of respect in a democratic society. So as was established in the Forstater case, the fact that a view is offensive does not necessarily mean that it's not capable of protection.
Thanks, Louise. So hopefully that helps just in terms of understanding what can be protected. I think that then leads us on to thinking, well, what exactly is the extent of that protection? And it's interesting that there has been commentary from the judiciary on this. So if we look at the Court of Appeal in Page, now this isn't a gender critical belief case. This was a case in which Mr. Page expressed views in which he was anti same-sex adoption. And here you can see from the quote on the slide that the Court of Appeal said that the freedom to express religious or any other beliefs cannot be unlimited. And similarly, the EAT and Forstater, the judgment does not mean that those with gender critical beliefs can misgender trans persons with impunity, and the claimant, like everyone else, will continue to be subject to the prohibitions on discrimination and harassment that apply to everybody else. So there is a limit, there is a cut-off point after which there will no longer be protection. And so what we end up looking at then is the manifestation or the expression of the belief. And again, going back to that Court of Appeal decision in Page, what the Court of Appeal said there is that there is a distinction between cases where the reason for the treatment is the fact that the employee holds or manifests the protected belief, as compared to cases where the reason for the treatment is that the employee has manifested the belief in some particular way to which objection could justifiably be taken. So what Mr. Page did in his case was he held his beliefs, and those were causing some issues within the trust. But outside of the trust, he was off speaking to BBC Breakfast News and Good Morning Britain and various print establishments too, and giving interviews where he was talking about his belief. And he was a very senior individual within the trust. And so the trust's concern was about how service users would perceive the trust in circumstances where this very senior individual was expressing the belief that in an adoption case, the child should only ever be adopted by a heterosexual couple so that they would have a mother and a father, that being Mr. Page's belief. And I think what was quite clear in the rationale for the trust's course of action that they took, which Mr. Page was saying was discriminatory, was that it was not the fact that he held these beliefs or that he had stated these beliefs. It was the fact that he had gone off and given these media interviews in circumstances where the trust had specifically said to him, if you're going to undertake media interviews, you need to expressly inform us in advance, and he hadn't done that. And that was the reason for the course of action that was taken in relation to him. And therefore, it was not discriminatory because it was not because of the beliefs, but rather that other course of action. And we can see that play out in the next case as well. This is the case of Higgs against Farmers School. So here, Miss Higgs was employed by Farmers School as a pastoral administrator and work experience manager. And the school receives a complaint about social media posts that Miss Higgs had shared on her Facebook page, in which she was essentially protesting against the teaching of same-sex relationships, same-sex marriage, and gender fluidity in schools. So the complaint comes into the school investigate it, they undertake a disciplinary process, and Miss Higgs is ultimately summarily dismissed for gross misconduct. She brings a claim in the Employment Tribunal. Her claim is based on direct discrimination and harassment, and it's based on her beliefs, and her beliefs were around, again, a lack of a belief in gender fluidity, a lack of belief that someone can change their biological sex or gender, a belief in marriage as a divinely instituted lifelong union between one man and one woman, a lack of belief in same-sex marriage, and so on and so on. She had various beliefs, but you get the idea. When the EAT came to assess what had happened here and whether the treatment that was being complained of was because of a protected characteristic, the Employment Tribunal was quite clear that that's not what had happened, and that here the concern was that because of these social media posts, Miss Higgs might reasonably be perceived as holding beliefs that were homophobic or transphobic, resulting in reputational damage to the school. And it was that rationale that led to them taking the decision to dismiss, not the fact that Miss Higgs held these particular beliefs. That decision has been appealed to the EAT, and we're currently waiting for a judgment. So I guess we can watch to see where the EAT take that decision on appeal. But for just now, that's where it's at. But it shows again this sort of fine line being drawn between holding a belief, and of course you have to be able to express or articulate your belief, otherwise what's the point in it being protected, as compared to that belief then being manifested in a way which is unreasonable or sort of unjustified. Then we'll go on to look at Forstater. So yeah, Louise has already been talking about this case in terms of the EAT's decision around the protection that's available. If we go back to the actual facts in the Forstater case. So Miss Forstater was a visiting fellow at CGD Europe. She regularly shared her gender critical views on social media and Twitter in particular, and some of her colleagues saw the tweets, considered them to be offensive, and so made complaints to CGD about them. And Miss Forstater was not offered a permanent contract of employment at the end of her visiting fellowship, nor was her fellowship renewed. And she said that that was direct discrimination against her on grounds of philosophical belief, because she had expressed her beliefs in these tweets, and these tweets had been complained about. So when the case went back from the Employment Appeal Tribunal back down to the Employment Tribunal in order for them to consider whether that was substantiated or not, it's a very long and detailed judgment, and probably in part because this case by that point was so high profile, being reported in the mainstream press, with various academic commentators commenting on it too. So they took time to go through each of the tweets that Ms. Forstater had tweeted, and what they concluded was that the tweets were a substantial part of the reason that she was not offered employment and she did not have her fellowship renewed. They said it would be an error to treat a mere statement of protective belief as inherently unreasonable or inappropriate. So coming back to this idea that if a belief is capable of protection or worthy of protection, you have to at least be able to communicate that belief, or to state that belief. They said that the tweets were provocative and they could have been made in more moderate terms, but overall they were not objectively offensive or unreasonable. So the Employment Tribunal in this case, having analysed each of the tweets, ultimately found that they did not cross this line into sort of unacceptable manifestation or expression. And it's interesting that for all of the tweets, or for all but one, that was a unanimous decision of the Employment Tribunal, so the judge plus the two wing members. For one of the tweets, it was a majority decision. One wing member did think that that tweet had crossed the line. And where they ultimately got to was that sort of mocking the opposing view is part of the common currency of debate, but that mockery that had quite often appeared in Ms. Forstater's tweets did not reach the level in the case where they would sort of take it outside the scope of protection. And so as a result, Ms. Forstater's claims in the whole, or on the main rather, were upheld, and there is to be a remedy hearing scheduled in order to determine how much compensation should be awarded to her as a result of that finding. Louise, pass back to you just on this competing rights point.
Yeah, so I think it's probably worth saying that now that we know that gender critical views are likely to be capable of protection under the Equality Act, employers may feel they're walking a bit of a tightrope between respecting those protected philosophical beliefs on one hand and ensuring on the other hand that persons that are transgender, gender fluid, non-binary are treated with respect and afforded the protections that they're entitled to under the Equality Act, as we've recently had clarified in the decision of Taylor against Jaguar Land Rover. The balancing point, I think, is given some consideration in the Employment Tribunal and in the Employment Appeal Tribunal decision of Mackereth against DWP and others. So Dr. Mackereth was a doctor that was employed by the DWP as a health and disabilities assessor. In his role, he was required to assess individuals for disability-related benefits, and as part of his role, it was anticipated that he would occasionally require to interact with transgender service users. He explained during his induction that he would not agree to use the preferred pronouns of transgender service users, which was at odds with the DWP's gender reassignment policy, which noted that the transgender service users should be referred to in their preferred pronouns and in their preferred gender at all times. Attempts were made to clarify the claimant's position to see if there was a way that his beliefs could be accommodated. So, for example, the DWP considered whether he could be given a desk-based job instead, but ultimately it was common ground that those jobs were only given to employees that had more than 12 months experience, which Dr. Mackereth did not, or whether he could assess only non-transgender service users, but ultimately it was agreed that a service user's wish to be identified other than by reference to their birth sex might only become apparent during an assessment instead of in advance through some form of triage process. So ultimately, this resulted in Dr. Mackereth leaving employment, having been employed for just over 2 months, and pursuing a tribunal claim for direct discrimination, indirect discrimination, and harassment. So, as I've explained already, the Employment Tribunal at first instance concluded that Dr. Mackereth did not have a protected philosophical belief. However, it did go on to consider the merits of the claim at the same time in the alternative, and concluded that even if Dr. Mackereth did have a protected philosophical belief, his claims were nonetheless without merit. And when Dr. Mackereth then appealed to the Employment Appeal Tribunal, while the AT concluded that he did have a protected philosophical belief, it did ultimately agree with the Employment Tribunal in terms of the outcome of the case based on its merits. I think suffice to say in the direct discrimination and the harassment claims that the less favourable treatment that Dr. Mackereth was complaining about wasn't substantiated. So, for example, he claimed that he had been suspended by the DWP in response to his objection to using the preferred pronouns, but the tribunal concluded that that actually is not what had happened. He had instead decided to leave work because he felt that he was distracted by recent events. But I think what's most interesting about this decision is consideration of the indirect discrimination claim, because it does give some insight into the balancing act that some employers will have to undertake. So, as a reminder, an indirect discrimination claim occurs where an employer applies a policy, criterion, or practice, which is commonly known as a PCP, which in practice has the impact of disadvantaging a group of people with a particular protected characteristic. And where such a policy disadvantages a particular individual that has that characteristic, that individual may then bring a claim for indirect discrimination unless the policy can be objectively justified by the employer. So in this case, the DWP applied a policy of requiring all health and disability assessors to use a service user's preferred pronouns irrespective of their biological sex. Dr. Mackereth had been subject to an individual disadvantage, and it was accepted that Christians would be subject to a group disadvantage by that PCP. However, the tribunal and the Employment Appeal Tribunal concluded that the PCP of requiring employees to use preferred pronouns was a proportionate means of achieving a legitimate aim. The legitimate aim that was relied upon by the DWP was ensuring that transgender service users were treated with respect in accordance with their rights under the Equality Act. And the PCP was found to be a proportionate means of achieving that legitimate aim, largely because the DWP did take steps to try to find an alternative way forward with Dr. Mackereth, such as considering whether, such as restricting the types of assessments that he was carrying out or providing him with that desk-based job. So even though those weren't practicable in the end, they were given consideration by the DWP. So ultimately, the indirect discrimination claim was dismissed. So I think in terms of where that leaves us, I think the key learnings, really, gender critical beliefs are capable of being protected as philosophical beliefs under the Equality Act. And as we've seen from the Forstater decision, action which is taken in response to a mere statement of those beliefs may be discriminatory. But that doesn't mean that those that hold gender critical beliefs are free to discriminate against or harass others. And that was emphasised by the Employment Appeal Tribunal in the Forstater decision, where it was made clear that those that hold gender critical views cannot misgender transgender persons with impunity. Employers should carefully consider the way in which a belief has been manifested and whether that has or is likely to cross the line, which is always going to be very difficult to assess where that line sits, and it's going to very much depend on the facts of each case. And finally, it's very important to handle clash of belief cases sensitively. So if you have a scenario where there is a person that holds gender critical beliefs, it's important to give them an opportunity to explain objections to policy that you may be implementing, and trying to move forward constructively from that. And in terms of actions that should now be taken, it's worth taking this opportunity to review all diversity, inclusion and equality policies and considering any adjustments or updates that might be required. It's also, I think, advisable to think about whether any policies that you currently have in place amount to PCPs for the purposes of an indirect discrimination claim, and if so, to satisfy yourself that there are grounds for arguing that the policy is a proportionate means of achieving a legitimate aim. And finally, I think as always, it's important to ensure that colleagues are regularly trained on acceptable workplace behaviours, the importance of respecting differences in values and beliefs, and any consequences for non-compliance with expected behaviours.
Yeah, I think that's all right, isn't it, Louise? Just in terms of, you know, in many businesses, they've already started their diversity, equality and inclusion journey. Some are more advanced than others, but if we're trying to create genuinely inclusive workplace environments, then cases like this and the learnings that we can take from cases like this, I think, are absolutely critical. And that piece around education for managers in particular, but for all colleagues, around respecting people's different beliefs, and the fact that there might be people within an organisation that you're working with who hold opposing beliefs to you, but we're trying to work out how you can have a productive and healthy workplace relationship with that person without beliefs getting in the way, I think is critical. Some of you on the session today are Workbox by Brodie's users, and so just to flag to you that there are materials on gender identity and discrimination on Workbox. If you've not had to look at those already, then you might want to have a look at those, and in particular their gender identity and transitioning at work policy might be one that you would want to have a look at. If you are not a Workbox by Brodie's user, but you would like to have a demo and see what it's all about, then you could let us know and we can certainly get that arranged for you. One of the Workbox by Brodie's team would be happy to deliver a session for you to show you the site and all of the great content that is on there. I'm going to flag what's coming up next. So we've got our Brodie's Academy is returning, or rather our Brodie's Academy in person is returning. And those sessions are going to take place at the end of this month in Glasgow and Edinburgh, and then the beginning of next month in Aberdeen. And we're looking at recruitment and new ways of working. So if you've not had the invitation for that yet, the details are on the slide. If you have had the invitation but not yet had a chance to sign up, then please do sign up, because places in each location are limited. Louise, are there any questions in the questions box?
Yeah, I've got a few here. So one is that in Higgs, you said that the issue was about Facebook posts. Does that mean we can take disciplinary action in respect of social media posts?
Yeah, great question. So yes, Ms. Higgs had shared certain posts on Facebook that had been posted by other people, and she did, as part of her claim, raise issues about the fact that she had an expectation of privacy in relation to her Facebook page. And I think when the tribunal was sort of considering her position in relation to that, they were not particularly minded to find that there was an expectation of privacy on Ms. Higgs' case. And that was predominantly because, notwithstanding the fact that it was a restricted Facebook page, so it wasn't open to the public, of the people that she was connected with on Facebook, a number of them were either colleagues or parents of pupils at the school. And so there was sort of, those people were sort of directly impacted by, or could have been directly impacted by, what she was posting. I think more generally in relation to social media, there's also this reality now that, of course, even if you have got your page locked down, somebody sees it, they can take a screenshot or print it off and share it. So it's not to say that if you're involved in a disciplinary case that you don't consider that as part of the disciplinary process, but it's probably got less significance now as compared to what we might have thought in relation to social media cases when we first started seeing those coming through. So that takes us to 1:30 and the end of the session. Thank you all very much for joining. You will automatically see that a quick survey pops up with 5 or 6 questions. It takes less than a minute to complete, but it is really important for us to get your feedback in order to shape the future of the webinar programme. So if I could ask you please to complete that survey when it pops up, that would be very much appreciated. And otherwise, thank you very much for joining and have a good afternoon.